Welcome to Do It for the Case Law, Friday, July 17th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket includes 61 cases across 11 circuits. We have coverage from James Taylor on criminal justice, Aisha Johnson on civil rights, Michael Reeves on Supreme Court and constitutional law, Maria Santos on business and labor, and Raj Patel on immigration and government matters. Please subscribe to the show for daily updates. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 23 cases, 15 affirmed, 1 dismissed, 3 remanded, 3 vacated and remanded, and 1 split outcome. Starting in the 10th Circuit, the court granted appointed counsel's motion to withdraw and dismissed United States v. Almagro Valdez from a conviction for illegal reentry after deportation, finding no non-frivolous grounds for appeal under Anders v. California. Over in the 4th Circuit, the court affirmed Karl Lamont Funderburg's conviction and sentence for conspiracy to distribute methamphetamine, cocaine, and fentanyl, reviewing the record regarding his guilty plea without a plea agreement. Moving to the 5th Circuit, the court vacated James Anthony Kirkwood's restitution award for lost income and mental anguish, holding that the Mandatory Victims Restitution Act does not authorize restitution for purely psychological harm or lost income absent a bodily injury. Olamide Alatayo Bello's appeal was remanded regarding the district court's denial of his motion to accept a late-filed notice of appeal without specific findings on excusable neglect or good cause. Adrian Marcel Brown, Eric Reed Maracio, and St. Jovite Youngblood were affirmed for conspiracy to distribute methamphetamine, wire fraud, and money laundering involving PPP loans and wire fraud, respectively. In the 6th Circuit, Naya Abbey's Fourth Amendment claims against Officer Terrence Stuckey were affirmed in part reversed, reversing the dismissal of a minor plaintiff's claims. Daniel Robertson, Christopher Blue, and Larry Ray Kaufman were affirmed on restitution for illegal image offenses, good faith warrant reliance, and commercial sex trafficking charges. The 7th Circuit remanded Robert Carter's compassionate release motion proceedings to the district court to determine if an extension of time is appropriate under Federal Rule of Criminal Procedure 4B4, rejecting the argument that docketing constituted an implicit extension. In the 8th Circuit, Kyler Dorsey, William Corbeen, Antonio Dontes Hoffman Jr., Andrew Jerome Bigby, and Thomas W. Pitts were all affirmed on denial of plea withdrawal, sentence reduction, felon in possession, methamphetamine distribution, and drug conspiracy charges, respectively. Over in the 9th Circuit, Karsten Rosenau's second amended complaint against Meta Platforms was affirmed without leave to amend, holding disclosures to law enforcement were lawful under Stored Communications Act exceptions. In the District of Columbia Circuit, Ahmed Salim Faraj Abukatala's 28-year sentence for the Benghazi attack was vacated and remanded for resentencing due to substantive error in sentencing leniency. David Jeremy Zobel's prior child molestation evidence exclusion was vacated and remanded as the district court applied an erroneous legal standard under Federal Rule of Evidence 403. Charles Edward Littlejohn's 5-year sentence for leaking tax records was affirmed. Finally, the Federal Circuit affirmed Blue Cross and Blue Shield of Kansas City Welfare versus the United States, holding claims regarding the Transitional Reinsurance Program were time-barred by the 6-year statute of limitations in federal statute. Back to you, David.
Thanks, James. Now let's turn to Aisha covering civil rights.
Thanks, David. We have 11 cases from across the federal circuits today. 5 were affirmed, 4 were reversed or vacated and remanded, and 2 were affirmed in part but reversed in part. In the 10th Circuit, the court affirmed Linda McCagnon's demotion claims against Cherry Creek School District No. 5, ruling she lacked a protected property interest in continued employment as principal. Also in the 10th, Wilson v. Stoltenberg affirmed qualified immunity denial for school officials who were deliberately indifferent to severe racial harassment. Over in the 3rd Circuit, Weinberg v. Attorney General New Jersey reversed and remanded on Second Amendment grounds, holding that New Jersey's assault firearm provisions and large-capacity ammunition magazine provisions violate the Constitution. The 4th Circuit vacated and remanded Gravely v. Hinchman, finding the district court erred in applying West Virginia's 1-year statute of limitations to Section 1983 claims for false arrest and malicious prosecution. Moving to the 5th Circuit, Thompson v. McCahey reversed dismissal of Section 1983 and First Amendment retaliatory arrest claims against individual defendants. Also there, Local 1374 v. Roberts was vacated and remanded due to mootness after a union officer resigned from the Civil Service Board. In the 6th Circuit, Crisp v. Scioto Ambulance District was affirmed in an ERISA retaliation claim where sharing nude images on duty was not protected activity. Wolf v. City of Detroit was also affirmed for lack of standing regarding emergency rental assistance funds withheld by the state. Finally, the 7th Circuit affirmed in part reversed 2 cases involving Class of 1 equal protection claims under Section 1983, allowing plaintiffs to amend their complaints. Rush versus Great Bank Trust Company was affirmed on fiduciary duty claims against executives during a company's sale under the Employee Retirement Income Security Act of 1974. Back to you, David.
Thanks, Aisha. Let's turn to Michael for constitutional law and habeas appeals.
Thanks, David. 7 cases today, 2 reversed and remanded, 4 affirmed, 1 dismissed. Starting in the Fourth Circuit, Keith Allen Wood versus Sean Strawn was reversed and remanded on habeas corpus relief. The court held the state court's double jeopardy ruling was not contrary to clearly established federal law under Section 2254 of Title 28. They applied the manifest necessity standard from Arizona versus Washington from 1978. Moving to the Sixth Circuit, Robert Leroy Hoteling versus Justin Soswanowicz was reversed and remanded on an Eighth Amendment failure to protect claim. The court found sufficient evidence for a jury to determine if the officer knew of the risk of harm under Farmer versus Brennan standards. Also in the Sixth Circuit, United States versus Anthony L. Ward was affirmed regarding suppression denial where probable cause existed based on corroboration beyond a single informant tip. United States versus Anthony Ziegler was affirmed on assault and racketeering conviction with evidence supporting gang motivation under the Vicar statute. Over in the Eighth Circuit, United States versus Tyler Denby was affirmed on competency and sentencing issues where no abuse of discretion was found regarding his hospital behavior. In the District of Columbia Circuit, Renat Akhmetian versus William Browder was affirmed on dismissal for lack of personal jurisdiction because contacts were insufficient under international SHU. Finally, in the Federal Circuit, Bieber versus Health and Human Services was dismissed pursuant to Rule 42 based on party agreement. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business and civil litigation.
Thanks, David. 15 cases in this block, 9 affirmed, 4 reversed or remanded, 1 dismissed and 1 denied. Over in the 10th Circuit, United States versus Martinez was reversed and remanded for an illegal term of supervised release exceeding the statutory maximum under federal statute. In the 3rd Circuit, in Re City of Chester, was affirmed in part remanded regarding dischargeable revenue streams under Title 11 of the United States Code Section 902 subsection B. In the 4th Circuit, Jose Anselmo Castro versus Todd Blanche was remanded after death threats were discounted by the Immigration Board. Alejandra Montesinos Cisneros versus Todd Blanche was denied for not being admitted in any status under the Deferred Enforced Departure Program, and Jesse Neer versus Enerco Group certified a product liability question to the South Carolina Supreme Court pending further proceedings. Over in the 8th Circuit, GT versus Liberty Mutual Fire Insurance Company was dismissed for lack of jurisdiction following a colorable remand order based on defective removal procedure under Section 1447 subsection C. Routine affirmances include Rhode Island Truck Center versus Daimler Trucks in the 1st Circuit, Assist Capital Management versus James Dondero in the 5th Circuit, Jose Nader versus New York Life Insurance Company in the 6th Circuit, Elmar Hotel Management versus Unite Here Local 1 in the 7th Circuit, Sweet versus McMahon and Quinteros versus InnoGames in the 9th Circuit, and Schindler versus Squires, Woodway USA versus Lifecore Fitness, and Kelly versus United States in the Federal Circuit.
Back to you, David.
Thanks, Maria. Let's turn to Raj covering immigration and government appeals.
Thanks, David. 5 cases today, 2 affirmed, 1 denied, 2 dismissed. In the Fifth Circuit, a district court dismissal regarding adjustment of status was affirmed because federal statute serves as a jurisdictional bar preventing judicial review of decisions under both the Administrative Procedure Act and the Mandamus Act. Moving to the Ninth Circuit, Dharam Singh versus Blanche's petition for review was dismissed due to substantial evidence supporting adverse credibility findings. Retish Vikash Singh versus Blanche's claim for protection under the Convention Against Torture was denied because generalized violence in Fiji was insufficient to establish a likelihood of torture. Also, the government's tax lien foreclosure against David Gould was affirmed as IRS declarations satisfy the initial burden of proof. Over in the D.C. Circuit, petitions regarding Environmental Protection Agency rules for steel manufacturing were dismissed because the agency acted within authority under the Clean Air Act. Back to you, David.
This concludes Do It for the Case Law for Friday, July 17th, 2026. A special thank you to James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel for their reporting today. We covered 61 cases across the federal circuits. Our outcomes included 40 affirmances, 15 other dispositions including reversals, vacated decisions and remands, and 6 dismissals. Several appeals were dismissed on procedural grounds. The significant rulings from today involve various criminal justice and civil rights matters where courts reversed or vacated lower court decisions. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow us for more daily updates.